What actually happens when a relationship ends? Not emotionally, but legally. For most people, separation is the first time they realize how many layers family law really has. From binding financial agreements and inheritances to parenting orders, mediation, and the growing reality of blended families.
If you have a de facto binding financial agreement, if you then get married, it's null and void unless you actually provide for the marriage in the de facto BFA, because a lot of people don't realise that, and then they go on and get married and they think that they're covered and they're actually not.
A lot of people just say, oh, you know what, this relationship's not working out, let's just separate or whatever, and you don't realise what that means. Then when things don't work out, it comes to it, oh, I didn't realise any of these things.
In this episode, Nadine Udorovic, partner at Nicholes Family Lawyers, return to unpack the next chapter of our family law conversation. What happens after the relationship breaks down? We'll talk about how binding financial agreements actually work when tested in real life, the differences between a parenting plan and a parenting order, and why only one is legally enforceable, and the complex reality of modern families, step-parents, grandparents, and teenagers who can now decide for themselves.
Every family is different. It's a very interesting line of work to work in because you're seeing all sorts of situations and how they can work or how they don't work.
Whether you're protecting assets, co-parenting after divorce, or simply want to understand what separation really looks like from a legal point of view, this episode is packed with clarity and compassion. Now let's get into it.
All right. Welcome back, Nadine. And
Thank you.
For those that have not seen your previous episode, why don't you give us the quick one paragraph summary of who you are, what you do,
Sure.
and we can talk a bit more about the topics. Yeah.
Thank you. So my name's Nadine Udorovic. I'm one of the partners here at Nicholes Family Lawyers. I'm a mum of tween twins who are about to turn 14. So very busy. I've been at the practice for coming up to nearly 20 years in a couple of months. I'm a family lawyer. That's a quick summary of me. Awesome.
And for those that have not viewed the previous episode, I recommend you have a look at that because we go through some of the the terminology that we're gonna discuss today. In terms of de facto, what's a binding financial agreement, and that sort of thing. So now, one aspect of family law is obviously the conflict resolution and getting a settlement and at the end of a relationship. But we previously talked about binding financial agreements, which are essentially legal documents that can help guide that process when you get to the end. I think let's just quickly revisit that and say, what sort of things that you would have in that binding financial agreement and how that can help in the case of settlements. And then we can talk about, the kind of sort of alternate dispute resolution that you practice. Yeah.
Yeah. The main things that people have in their binding financial agreements is all around their asset protection. So largely in the event that we separate, how are the assets going to be distributed? Is spousal maintenance going to be paid, etc. So that's really the two main issues. It's assets, and that can be all of your non-superannuation assets and your superannuation assets, and maintenance. They're the two key categories that it provides for.
Mm-hmm. And it's one of those documents that even though you're writing one today, the asset pool can look very different from expectation. And, is this something that if you were a proactive individual, you would get that updated, say, every 5 years, for instance, or is that something that you see in your practice?
I don't see a lot of them being updated because once they've been signed, they're binding for all time until such time as you separate, and then they have to come into play. If the parties want to have an agreement that they will revisit them, if you like, to update them, then that should be recommended to be drafted into the body of the agreement, because otherwise there's no requirement for the other party to agree to, for example, in 5 years' time, anything. Yeah. The other big thing I probably should say that I probably didn't say on the other episode was that if you have a de facto binding financial agreement, if you then get married, it's null and void unless you actually provide for the marriage in the de facto BFA. So that's just really important, because a lot of people don't realize that, and then they go on and get married and they think that they're covered, and they're actually not unless it's made provision for it.
Ah, interesting. So in the way that I look at this, it's not quite like, will and estate that you will say, oh, let's update it every now and then because the asset pool has changed.
No, it's quite different. It is very different because things fluctuate from day to day. So you're not going to do it day to day. There's a bit that goes into it. There has to be disclosure, etc. So, I don't think I've actually even had one, maybe one in my whole career that's been updated along the way. The main ones that would get updated potentially is if you have a de facto one and then you get married and there was provision for the marriage one, then you could look at updating it. But generally speaking, once they're signed, you don't look at them again until you separate.
Okay. And what if in this situation where I'm just putting all my scenario hat on, what if you then have like a grandparent that has passed away and there's a estate coming into that relationship? You already have a binding financial agreement, and you may not have covered that adequately. What happens then?
If you haven't dealt with it, then it's potentially going to form part of the asset pool if the relationship continues. Most of the ones that we would do, the recommendation is that they should and would provide for future inheritances, because that's often the biggest thing that people want to protect is not only what they have now, but they would know, look, I'm probably going to get a pretty sizable inheritance and it might not be that far away. I want to make sure that that doesn't come into the play. So it does need to be drafted and referenced. Otherwise, if it hasn't been considered, then it's potentially open for scrutiny. And it could possibly come into the asset pool.
Yeah. And essentially what that is, it just gives certainty to what's happening to the future asset pool whenever that happens.
Yeah, it's asset protection and it does provide certainty. And what I always say to my clients is once I've signed them up, put it away and don't look at it. Don't bring it out on a Saturday night when you're having a bottle of wine together and keep talking about it. I mean, I know it sounds silly, but people do that. Just put it away. We'll keep a copy. The other side has a copy. Don't keep looking at it. Just move on, and it's there if you need it, but it shouldn't then be the defining point in the relationship either.
Yeah, that's interesting. I've got a question. I've heard other places where if you have a binding financial agreement, it feels like that's almost protective in a relationship because it means that you're able to discuss these topics before you get into a relationship. And in your experience, do you see that they've done a binding financial agreement and then later you come back and having to deal with the end of that same relationship you've written the BFA for?
It does make it easier because it should then be very smooth. And I've just recently done one where the parties then ultimately separated a fairly long time after they signed a financial agreement, and it's been very straightforward. And that's ideal because that's why you do them and you spend the money and the time investing into them, because it then should just be pretty seamless. And in this instance, it has been. I have had experience in the past where it hasn't been so seamless for different reasons, but it should make it an easier transition away from that relationship if it ends. Yeah.
And I guess, say you did, 1,000 BFAs, what, and this is, I guess it could be a guess, how many do you end up seeing, end up in divorce? Yeah. I mean, you've had 20 years in the game now. So.
Well, yeah, I mean, that's the thing. So, I've had maybe I'd say 5, that I've actually signed, have then come back to me because the thing is, they may not necessarily come back to the initial lawyer that they had drafted or sign it. But probably I would say 5, and that's not many. So hopefully all those people are still happily together. Who knows? Or, for example, they haven't needed to go back to a lawyer because it's been really straightforward what was going to happen, and then they just sort it out between themselves.
Right. Yeah, so that's an interesting statistics. I'm almost interested to understand a bit more, because if it feels like by having those agreements, it's almost prophylactic against separation, because either it's a lot clearer, or perhaps people who are less likely to divorce will have a binding financial agreement. Chicken and egg.
Yeah, exactly. Or sometimes it may take the pressure off because the party that felt like they needed to protect themselves feels protected. So they're sort of feeling very comfortable, and it's not an issue that, money's obviously one of the big issues of why people separate. It's one of the main reasons people separate is money. So I guess when you take that off the table and you don't have to worry about it, then maybe it makes things more harmonious. So that could be, but yeah, look, I haven't had many. So hopefully that's a good sign.
Yeah, hopefully that's a good sign. And if that's that's the actual statistics, it's something you will almost recommend everyone to have one before you get married. And
I think there's a large section of the population that would benefit from having them. That's for sure. Yeah.
Yeah. Beautiful. And whilst we're talking about binding financial agreements, in the name, that's a financial and asset protection aspect of it. Is there say a binding childcare or binding children agreements, parenting agreements? Yeah, as well. Yeah.
So there are two documents. There are really only two documents that can determine parenting arrangements. So the first one is a parenting plan, but that's not binding and enforceable in court. And then there's a parenting order, which is effectively an order that's made by the Federal Circuit and Family Court, and they are binding. So that's really the only two ways that you can document arrangements for kids. Some people never have either, and they have a very amicable arrangement in principle agreement for their kids, and it works really well, and they never need lawyers. But for the ones that do, I'd always recommend a parenting order, particularly in this day and age where kids have passports, they're moving overseas, they're, traveling extensively. Parenting orders cover a whole range of issues, not just time. They can talk about things like schooling, education, medical issues, mental health intervention, movement across borders where they can and can't travel to, passports, who else they can come into contact with, special occasions, school holidays, all those sorts of things. So there's a lot in them. Yeah.
And obviously we're talking about all of this because we want to have as much collaboration with, the parents as possible. And, in this modern day family, it can be an utter mess sometimes, with stepchildren and all that sort of
blended
thing.
Families. They're very common. Blended families are everywhere now. It's very, very common.
Does it make your job a lot more interesting or complicated in those situations?
Yeah, it probably makes it more interesting and or complicated. But yeah, there's a lot of, stepchildren and step parents and blended families, and there's no norm now. There's no sort of normal family. Every family is different. And that's probably, it's a very interesting, line of work to work in, because you're seeing all sorts of situations and how they can work or how they don't work. So having that certainty, I think, does really help, though.
Yeah. And so that's, if you really needed that would be in a parenting plan. And I'm just making up scenarios where you could have, a man and a woman, they both have, children that they ended up taking ownership over after their respective separation. And then they come together to form a family where there's like two from the father, two from the mother. But they could still be young, and then they work in that family relationship. And what happens when they separate?
So, that's a bit more tricky, because generally speaking, you only see the parenting order between the two, if you like, biological parents. And so, you don't necessarily automatically have a parenting order for a biological parent and a step parent in respect to those children, because the proceedings are only between the parents, not necessarily the step parents. But I have had cases where, for different reasons, it has been appropriate for arrangements to be in place for the step parents to still be able to see their stepchildren even at the end of a relationship. But it doesn't necessarily automatically qualify in terms of a parenting order. It depends on the circumstances, and they're a lot more complex because there's also another category of cases where we act for grandparents who can apply to the court parenting orders for their grandchildren because they're also considered interested persons under the legislation. But again, it's not the norm that when a couple separate, automatically the grandparents get, strict time with their grandkids, because you would normally see that the grandparents continue to see their grandchildren when they're seeing their own sibling and their side of the family. But there are some cases where, for different reasons, due to drug and alcohol issues or mental health issues, or one parent may have passed away or whatever it might be, the grandparents step in and they can seek orders under the Family Law Act as well.
Yeah. That's just that's another whole complex topic in there as well.
That's another episode as well. So yeah.
Yeah, awesome. And so let's get back to the the topic at hand. It's about that collaborative approach to sort of family law. Now, explain what that means and how that's different from the typical sort of the typical setting. Yeah.
Yeah. So when you're looking, I guess, at the two pathways, you've got the legislative, litigation pathway. And then the other pathway is really the alternative dispute ADR pathway. And that can take lots of different forms. So there's family dispute therapy, and that can be lawyer assisted or not. And that's where parties can engage a family therapist to try and assist them to resolve both of their family law matters, whether it's financial or non-financial, so parenting. And that can be done with or without lawyers. And there's specific, agencies and people that practice in that area of the law that we can, engage with. Then there's another form of practice called collaboration. So I'm one of the collaborative practitioners here at the firm, as well as our managing partner and another one of our partners. So collaborative law is effectively where you agree to go down the collaborative path with another collaborative lawyer. And it works on the basis that you have a series of meetings with your clients, and you sit around a board table together with both parties and their lawyers. You can engage a financial neutral to come in, which is an accountant, and you can also engage a child psychologist to come in as well to talk about parenting issues. And you basically set a series of 2-3 hour meetings over the course of a number of months, and you work collaboratively to resolve the agreement. At the outset, you sign a collaboration contract, which talks about the way you will and won't engage in the process. You still get valuations, you still have disclosure, all those sorts of things. You still give your client advice, but you do it in a very, very collaborative process. And you agree not to go to court. If you don't resolve it through the collaboration process and it doesn't sort it out, then if the matter does go to court, the collaborative practitioners can't be involved. You'd have to go and get a different lawyer. But if you don't resolve it through collaboration, but you are able to resolve it through negotiation after, you can still have the same lawyer. So I've found in the past when I've done collaborations very successful. So that's one aspect. The other aspect is, I guess, mediation. And that's where we engage barristers and a mediator. So we have a formal mediation. We set aside one whole day. We have them here at our office, or we have them at the Victorian Bar Mediation Centre or a mediation centre somewhere in Melbourne or wherever it might be. I've had many interstate. It depends. We've got clients all over the place, so happy to jump on a plane and go interstate for mediation. But you have a mediator that's appointed who is not there to advise or act for either party. They're there to mediate the two positions, and that's a member of the Victorian Bar, so a barrister. And you each have your own barrister and your solicitor representing you. You exchange a mediation position paper. You still get valuations and disclosure, and you might be doing that through the court process, or you might be doing it without the court process. But mediations are really, really successful tools to sort out issues, because you are basically all allocating a full day to sit there and work out a solution to the problems. And it's great because you generally would have 3 barristers present, and 2 lawyers. So between 5 legal practitioners, the majority of cases will resolve at a mediation.
Jeez. Yeah, that's very heavy.
It is, but I mean, it's a really effective tool to sort out issues for people. And if parties can have a one-day mediation and sort out their parenting and property matters, they'll save themselves a lot of angst and money, as opposed to going through the litigious path. So we do a lot of mediation work here, a lot. And even if you do end up having to go to court for whatever reason, the court will also make you do a mediation. They will insist that a mediation happen before the matter goes to a final hearing, because the reason for that is that the large majority of cases will either settle at a mediation or the next day or a couple of days later. I've had a few more complex property mediations and parenting cases where we do mediations over 2 days. So we actually set aside 2 full days for them. And so that works really well where you've got some really complex issues and you really think that you need more time. And we've also got a lot of our retired judges that have come back and they're working as mediators. And that's fantastic because in some cases you do need a very experienced mediator. And what better person than a judge who used to make these decisions in court? We've got access to some really fantastic people that can really help. And I think mediations are a great way of trying to sort out issues, because ultimately then the clients are the ones that make the decision. They drive the outcome. We're there to give advice, but they ultimately say yes or no, as opposed to if they go to court, ultimately the judge will adjudicate the outcome. They won't have a say. They take back the control, which I think is, really important.
Because it's risky sometimes to go down that litigation and that confrontational pathway, isn't it?
Court's always risky. So, I mean, no lawyer can tell you what the outcome is going to be 100% because we're not making the outcome. We're not adjudicating the outcome. We can give you a range of we think it's going to go this way. Probably we're confident, we're not so confident, et cetera, et cetera. There's cost issues to consider or cost applications when you're in court as well. But at a mediation setting, it's confidential, it's private, the court's not going to know about it. So, people can speak openly and freely. They can bring support people with them, whether that's a family member or a friend. I've had clients in the past who have brought their counsellor with them or whatever it might be. And the parties don't need to actually see each other. They don't need to be in the same room together. We generally keep them separate. The lawyers all meet, but the mediator will see both parties, but the parties don't necessarily need to see each other because for a lot of clients, they're very nervous, or there may have been domestic violence, or they're feeling maybe a bit of a power imbalance or something like that, or they just feel like, look, it's just going to be too hard for me to see my ex and try and make some decisions today. And that's very understandable. So generally speaking, we keep parties separate. Sometimes the parties want to see each other, but generally they're in separate rooms, and that works really well.
Yeah. I guess if they can be in the same room and having a conversation with each other, they might not even get to mediation. They might have, gone through that collaborative approach and be done with it.
Yeah, well, that's exactly right. And so in some cases, the mediator will request that they get the parties together for a short chat, but it depends on the circumstances. I mean, I had one collaboration, I'll never forget this. The parties would come together and leave together. That's how collaborative they were. And they'd leave the collaboration and go and have lunch together and then go and pick up the kids. Now, that's not your typical scenario. But generally speaking, most clients would prefer not to see the other party when they're mediating because they really want to think clearly. They want some time. They want some space. They don't want to feel the emotional feel that they're going to feel when they see that person. It can set people back a little bit to try and help them, make a decision on the day.
Do you see there's a particular type of people or personalities that work better from a collaborative approach, and then there'll be some people that just cannot?
Yeah, I mean, I think, look, if you're doing a true collaboration where you're going to be sitting around the table with each other, which is very different to mediation, clearly if the parties are, clearly if there's a significant amount of angst and they are really, really irate, and or abusive to each other, or there's been family violence and intervention orders and
that's not going to work. Yeah.
It's not going to work because you don't want people yelling and screaming at each other across the table, screaming profanities and making threats and so forth. We would never allow that to occur. So that's not going to work. So there does need to be some level of, amicability, if you like. I think the other thing is if you've got a party that's, drug and alcohol affected or has really, really, really significant mental health issues, it's not going to work because they're probably not going to be able to sit there and control themselves or contribute to, the situation effectively. So we sort of have to triage the clientele a little bit with respect to that. But I think a mediation being very different where the parties are not in the same room together, that works for everyone. And even if there are intervention orders or there has been family violence, we can still effectively have mediations. We can have remote mediations, so we can do them on Teams like we are on record today. So the parties don't necessarily have to be at the same venue. If there are safety concerns, we would probably do it at separate venues, and I've done quite a few of them. And that works effectively as well. So we sort of tailor them to the needs of the clients. Yeah.
Yeah. And you get a feel of them after having a chat with them and how they feel about the other person.
Yeah, absolutely. And look, I mean, if for whatever reason things get really heated, we just call an end to it or call a break. And, I've had that situations unfold, but that's to be expected because of the line of work that we do. People are very raw, and emotional, and the littlest thing can set people off, and so we're equipped to deal with those situations quickly as well if we need to. But generally speaking, mediations are really successful, and I think they're a great tool that people should use.
Yeah. So you mentioned earlier that in terms of the parenting aspect, you really need a parenting order, which is a court-driven process. You can still have the collaborative approach and mediation or mediation, and then still get that parenting order, isn't it? That's different from the litigation aspect.
Correct, yes, because you can get a parenting order by consent. So you don't need to be litigating to come out of it with a parenting order or a financial order. You can apply to the court with consent of both parties for financial orders and parenting orders. And we do that a lot of the time as well. Yes.
Okay. Do most divorces end up with both of those orders, if it's applicable? Or
I think the majority do in this day and age. And I think particularly with parenting and children's matters, because, we're very much an international community and, people are moving here, there and everywhere. And it's important to have, restrictions and understandings of where children can go and what parents can do with their children and, where they're going to school and what the parameters are around, different issues. So I think the majority of people that separate end up with some set of orders, whether it's financial, parenting, or both.
Yeah. And you mentioned in the past that you can have a binding financial agreement. And if you had a binding financial agreement at the separation stage, you may not need a financial order anymore. Is that correct? Or
yeah, that's correct. Yes. Yep. You can just operate in terms of what the binding financial agreement provides for. Yes, that's correct.
Okay. And so, but really for the children, there is only that parenting order that
that's the only document. Yeah, it's the only document that's binding. But as I said, you can have a parenting plan, but that's not binding and it's not enforceable. So my view is probably you're better off with a parenting order than being that doesn't provide protection if you need it.
And what sort of protection are we talking about? I guess moving interstate or having those quarantine time are things that are binding, obviously.
Yeah. Yes, absolutely. So, with a parenting plan, I guess it's just an agreement in terms of intention. But for example, you might have a situation where the parties have got a parenting plan and then one party just relocates without the consent of the other parent interstate. So having a parenting order would then mean that you could seek what's called an urgent recovery order, and you can seek to enforce and rely upon the parenting order, which probably wouldn't have provided for the interstate travel. Then when you have child abduction matters where children are taken outside of our jurisdiction, again, parenting orders take on a whole new level of, issue. Some parenting orders can be registered in international jurisdictions as well. So having a parenting order can, safeguard against, those sorts of things. But look, in some instances, parents do what they want to do anyway, even notwithstanding having a parenting order in place. So, but it does give a different level of protection if required.
Yeah, because I work in an emergency, and we see some, you hear about cases where there's child abduction and all sorts of really funky situations. And at the end of the day, a court order is only as good as the person that's willing to abide by the legislation, isn't it?
Yeah, that can be true in many cases. Yeah, that's very much true. Absolutely. So, I don't really see a lot of parenting plans anymore. They sort of came in many years ago, but I think if people are going to spend the time and effort and energy on a parenting plan, you're probably better to just get a parenting order, because then if something does happen, you can quickly get into court to enforce it. A parenting plan, the court's not necessarily going to, enforce that, or they don't have to consider it because it's not a binding document.
Yeah. And when you say, enforcing an order, that could be, putting a control on the passports or going overseas, that sort of thing. Does that include that? Yeah. Yeah,
absolutely. Yes. Yep. And we do a lot of that work in terms of seeking what's called airport watch list orders to put children on the watch list to prevent the movement across the, international borders. But you can't do that without a court order. And so then, and it can also be referenced then in a parenting order as to, well, who's going to retain the passport? And in what circumstances does the child's passport get released to the other parent? And if it does, when does it need to come back to the other parent? Is it within 4 days of return to Australia? Is it 7 days? There's all those sorts of things. The other thing is with, children traveling, there's, conversation in parenting orders about the Hague Convention and the non-Hague Convention countries. So, what countries can children, travel to, and what do the parents agree to? So, for example, a lot of Australians and a lot of Aussies, we go to Bali. Indonesia is a non-Hague Convention country. So, sometimes, well, that just means that they're not signatory to the international convention that protects the movement of children across borders. So having parenting orders that provide for, well, children can travel to, these countries and not these countries. That's really the only way to then, be able to, prevent parents from, taking those steps. But again, if children are not on the watch list order and a parent has free access to their passport, they can effectively take the children anywhere, really. So, and that does happen from time to time.
Yeah, yeah. Oh, there's just there's so much in it, isn't it?
Yeah, that's a very complex area. There's a lot in that. Yes. Yeah.
It sounds like from the financial and asset protection, that's almost relatively easier than the children piece, because and obviously as children get older, they have a mind of their own, even though they
vote with their feet.
Yeah, exactly. So I guess one of my last questions is that, when you have a child that has a agency of their own, when does that agency get factored in, and can that change?
Yeah, that's a really good question, because at the moment I've got a couple of cases where I've got kids involved who are sort of 15, 16. So kids at that age and, teenagers and so forth, they are very much voting with their feet, because also they've got the maturity to be able to start to make more decisions for themselves. And so where you have a case where a client might come to you and say, look, I'm not seeing my teenage child, we've got to make a really tricky, hard assessment there, because we know how long the litigation's going to take. If it takes 2 years, there's no good a court making an order for a 17-year-old, because within 12 months they're outside of our jurisdiction anyway.
Adult. Yeah.
And they're an adult, unless you've got a special needs child. And that might be a very different situation from a maturity perspective or mental health issue. So, but in the large proportion of those cases, going to court's probably not going to really help anyone, because by the time you get a court order, you may not be able to do much with it anyway. I mean, it's very hard to physically restrain a 16 or 17-year-old and get them into a car if they don't want to go. So using family therapy is a really good way then in those instances to assist parents in those conundrums where they're having difficulty with, teenage children. And that's where the other aspect of, our work can come into it with, family dispute resolution and family therapy, and lawyers can be involved in that process to assist with child psychologists and all those sorts of things. So it's very case specific depending upon the age of the child.
Yeah. So, I mean, the thing is that when, if the court order was made when they're like 10 years old and, in 4 years later, they're 14 and they want to have a different arrangement.
Correct. Yes.
What do you do?
Yeah. So the starting point is getting what's called a family report from a child psychologist, if the parties agree, who can meet with both parents and the child to talk about, well, what is the current arrangement? Why does the child want it to look different? And what's the child saying? Because at 14, 15, they're old enough to express themselves. They can go to a meeting and so forth. So that might be one of the first things we do, or we might recommend some family therapy. So child inclusive family therapy with the parents to try and work out why is the child wanting to have a different, time arrangement with the other parent. But there's often a reason behind it. There's often something that's happened or happening in the environment to dictate that. And that comes out through the course of, investigation and so forth.
Yeah, yeah. And that can then be reported back to the courts to change the order, or can one parent say, you know what, that's fine if you want to spend more time with mom or you want to spend more time with dad, I'm more than happy for that. And can you also have a collaborative approach on that to just get a order by consent?
Yeah, absolutely. So if at any time after a final parenting order is made, if the parents decide that they want to change it, they can do that by consent. Approaching the court to amend the orders, or they don't even need to amend the orders if they don't want to. If they're amicable enough that they can work within the parameters of an agreement in principle, they can do that. Or if they're not in agreement and they're not aligned, then applications to the court on different bases and pursuant to the legislation would need to be made. Yes.
Yeah, yeah. And then you go through that litigation process, if it gets to that, or mediation.
Yeah, absolutely. Or mediation on some level. Yes.
Yeah. Awesome. That's a really complex topic. Yeah.
It is very complex. I hope I've sort of been able to explain it in a user-friendly way, because it's very layered and there's a lot in it. Yeah.
Yeah. I think it's really good for our listeners and viewers to see how many layers there are and to even consider all of those layers, because I think a lot of people just say, oh, you know what? This relationship's not working out. Let's just separate or whatever. And you don't realize what that means. Or when you get married or when you move in together, you don't realize what that means. And then when things don't work out, it comes to I didn't realize any of these things.
Yeah. Yeah. And it can be very complex to untangle situations. Yeah. Yes.
So, Nadine, thank you so much for joining us again and deciphering some of these things. And
no, you're welcome. Yeah. Thank you for the opportunity, and I hope that it's helpful for the listeners. And I guess if anyone needs any assistance, they feel free to reach out, and happy to have a chat.
Absolutely. Now, thank you so much.
This podcast is for educational and entertainment purposes only. The information and opinions shared are not intended as personal financial advice. The content presented should not be relied upon for making financial, investment, or other decisions. Listeners are strongly encouraged to seek the advice of qualified financial or legal professionals before making any financial decisions. While we aim to provide valuable and accurate information, we make no guarantees regarding the completeness or accuracy of the content. Any reliance on the information provided is done at your own risk.